Hi, it's Doug Eisenberg, and the lesson from the domain name dispute case I'm talking about today is a basic but important one that I often tell my clients. Filing a UDRP complaint is not a simple task of filling in the blanks. And when a trademark owner doesn't take the time to provide appropriate factual and legal arguments, a panelist is likely to deny a request to order the transfer of a disputed domain name. Plus, in the case I'm about to discuss, the panelist even scolded the trademark owner for its failures. The case I'm talking about was filed by an Indian company known as Nalli under the UDRP, the Uniform Domain Name Dispute Resolution Policy. The decision was issued by a WIPO panel in August 2021. Now, according to the decision, Nalli manufactures and markets clothing and fashion accessories, and its website uses the domain name nali.com. The UDRP complaint that it filed was against the registrant of a similar domain name, nali.life, which contains just a single letter L. The registrant of that domain name apparently used it to operate a website selling a skin product. Now, Nalli, the complainant, said that it was established in 1928 and has used the Nalli trademark on its product since 1935, which is protected by registrations in India, the United States, Australia, Canada, and the United Kingdom. Nalli also said that it is well known for its pure silks and saris, and its website sells a wide variety of these products in various fabrics and styles and different price points. The company has filed a number of UDRP complaints in the past, most but not all of which it has won. Now, in the case I'm talking about here, Nalli argued that the respondent's website, which you can see in this screenshot, was bound to induce the public into believing that it had a connection with Nalli, which is not the case, that there could be no plausible explanation for the registration of the disputed domain name other than to misappropriate the reputation of the Nalli trademark, and that the respondent should have known of the Nalli trademark. Now, in this case, the registrant of the disputed domain name didn't bother to file a response, which happens more often than not in UDRP proceedings. But that never means that the panel is guaranteed to issue a decision in favor of the trademark owner, because there's no such thing as a default judgment in UDRP cases, since the burden of proof is always on the trademark owner to establish all three elements of the UDRP's three-part test. As a matter of fact, I wrote a blog post on this topic a number of years ago called "The Most Embarrassing Way to Lose a UDRP Complaint." I've included a link to that blog post in the description of this video. In this case, the panel found that Nalli had failed to meet the UDRP's burden, at least on the second and third elements, which relate to whether the registrant of the disputed domain name has rights or legitimate interests, and whether the domain name was registered and is being used in bad faith. The panel apparently was not very impressed with Nalli's arguments, which seemed to rely on some broad statements about its own trademark and perhaps little else. As a result, here's part of what the panel wrote. The complainant's trademark does not appear to be as well known as the complainant asserts. It may be well known in India and in Asia, and in certain demographics of the population around the world, but the panel considers that it is not a widely known trademark in the general population throughout the world. There is no evidence in this case that the respondent, who has an address in France, if that is indeed correct, should have been aware of the complainant or its trademark when registering the disputed domain name. The panel then went on to criticize Nalli's shortcomings in the complaint that it filed. Even if the respondent knew or should have known of the Nalli trademark, the complainant has not offered any evidence that the respondent proceeded with the registration of the disputed domain name for a bad faith purpose, rather than for the purpose of registering a domain name that corresponds to the name of what appears to be the respondent's skincare product. It is generally not acceptable to file boilerplate complaints only containing conclusory arguments. That is particularly so when the arguments made are not relevant to the facts. The complainant's complaint here verges on spurious. The panel even uncovered and cited a previous UDRP decision that Nalli had lost in 2019 involving the domain name nalligroup.com, in which another panel found that Nalli had engaged in reverse domain name hijacking. Now, despite these losses, Nalli still has an overall winning track record in about 10 UDRP cases that it has filed. But as this decision shows, Past performance is no guarantee of future success. Every UDRP complaint is judged on its own merits, and the failure to cite appropriate evidence, something I always expend considerable time and effort to do on behalf of my clients, is never something that should be taken for granted. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my Gigalaw website. And be sure to subscribe to the Gigalaw YouTube channel to be notified of future videos discussing other UDRP cases. Thanks for watching, and see you next time online.